It's all still too hard, you know?
Chuck Milne hits the road to visit someone he hasn't seen in years, but thinks about every day.
She was very gregarious, very outgoing, and loved people and loved attention.
He's talking about his big sister, Leona, an avid baseball fan.
She was a tremendous Braves fan. Had all kinds of Braves memorabilia.
Instead of planning their next game together, this is what their visits look like today.
How did you find out that she passed away?
I walked in and found her dead.
It all happened here at Rose Lane Health and Rehabilitation Center in Marietta, Georgia in April 2018. The 73-year-old was admitted to help her walk again following foot surgery, a temporary stay. But within days, nurses noticed something wrong.
They called and said she was having a little trouble breathing.
Chuck says he begged the nurses to call an ambulance, the hospital less than a mile away, but they wouldn't do it. That's because Leona had signed this, a DNR, or Do Not Resuscitate order, which prohibits medical staff from performing life-saving measures like CPR if a person's heart stops.
And I said, you don't understand, she's not capable of signing a DNR.
Why wasn't she capable? Leona grew up with a mental disability her entire life, the cognitive ability of a 9 or 10-year-old as an adult.
Well, I told her she didn't have the mental capabilities to sign one. There's no way.
And what was their response?
Their response was, well, we have one signed.
There's no coming back from a DNR. It is the ultimate order.
Mike Prieto represents Leona's family in a pending wrongful death lawsuit against Dr. Sarah Sambandham, the facility's former medical director and the physician ultimately responsible for Leona's care.
When we first looked at the case, we really just looked at it on whether or not Ms. Milne had mental capacity to execute a DNR. It wasn't until later that the rest of the story came out.
This is a DNR form for Ms. Milne.
The rest of the story revealed itself during this 2021 deposition of a social worker who worked at Rose Lane. According to Georgia law, before a DNR order is placed on someone mentally disabled, 2 doctors must evaluate the patient and sign the order. It must then go before an ethics committee for final determination. Similar protocols other states also require. The social worker said none of that happened at Rose Lane. In Leona's case, her DNR was photocopied with 2 doctor signatures already on it before the form was ever given to Leona.
Were they original signatures or were they photocopied versions of signatures?
We had copies of those.
Where did you physically retrieve a pre-signed DNR form from?
I had them in my notebook.
So no doctor was evaluating these patients?
Correct. In fact, the testimony that you will see from the social worker is that they would go to the resident and say, do you have a condition that will lead to your imminent death?
You're telling me Ms. Milne checked the line next to the sentence that says the resident has a medical condition which can reasonably be expected to result in the imminent death of the resident?
Yes, she did.
Did she tell you what condition she thought she had which was expected to result in her imminent death?
I cannot remember.
Leona's brother remembers why she was originally admitted.
She got an infection in her toe.
One more thing about Leona's DNR order. Remember the 2 doctors' signatures on it? According to court records, one of them included a doctor who resigned from the facility before Leona was ever admitted.
She had been gone for 7 months before the DNR in our case was ever executed.
And she is on Leona's DNR form?
Correct.
So she didn't even work there?
She didn't work there. She didn't work there.
It wasn't the only time it allegedly happened. These are 194 DNR orders, part of the lawsuit, that were allegedly photocopied with doctor signatures on them before patients were ever evaluated. Take a look. Sets of dozens of DNR forms with the same doctor signatures, and all signed when Dr. Sarah Sambandham was the facility's medical director. The identities of the patients unknown because the facility redacted their names, citing privacy rights.
The scary thing is how many other victims of this physician are out there who have no idea. That's terrifying.
Through her attorney, Dr. Sambandham declined to be interviewed, but denies any wrongdoing in court filings. According to this deposition of the doctor taken in August, when asked about the DNRs, she said they looked photocopied. She also claimed she had no idea the practice was happening in her 4 years as the facility's medical director, saying it had never come up.
It is illogical for a physician to see these pre-printed forms in 194 of her patients' files and to claim that she had no knowledge of it.
According to records from the Centers for Medicare and Medicaid Services, at least 4,800 long-term care facilities across the country since 2019 have violated patient advance directives, which includes DNRs. It's unclear how many of those violations involve DNRs improperly ordered without patient or legal guardian's consent.
Look, I'm in love. I'm all shook up.
Grace Scherer's family believes their daughter is among them. Born with Down syndrome, her father Scott says her condition never slowed her down. The two cooked, hunted, and loved taking long car rides together.
She was a gift. She was an absolute gift.
She sounded like she was your best friend.
She was my best buddy.
In October 2021, the 19-year-old contracted COVID and went to St. Elizabeth's Hospital in Appleton, Wisconsin, for treatment. Her parents had medical power of attorney. Scott says Grace's doctor asked if they wanted medical staff to resuscitate their daughter if things went downhill, but never mentioned a DNR order, nor did they request one.
Absolutely not. Why would we ever request it? It makes no sense. I mean, we're expecting our daughter to get out of there. We're not expecting her to die.
The doctor's attorney told the state in this letter that they had 3 conversations with Grace's parents and received clear consent from the family to place the patient on a DNR. The hospital, too, says the doctor documented the same conversations. But according to Wisconsin law, DNR orders must be signed by 2 people, the doctor and the patient or their legal guardian. Patients must also wear bracelets like these to notify staff a DNR order is in place. Grace's parents say none of that happened with their daughter. The hospital and doctor declined repeated requests for an interview. Grace died with a DNR order placed in her medical chart. Her parents say they never approved.
And these nurses from the hallway, they won't come in the room. They holler, she's DNR. And we holler back, she's not DNR, save our daughter. They refused, they would not come in the room.
Wisconsin's Department of Safety and Professional Services investigated and found the doctor didn't break the law because of the location where the physician worked at the time. The agency telling Investigate TV that Wisconsin statute does not apply to physicians operating in a hospital non-emergency setting, meaning a written DNR is only required when the doctor works in an emergency department or an out-of-hospital emergency setting. None of that makes sense to Grace's dad.
How can people be immune from liability for killing somebody?
Medical staff accused of playing God, allowing patients to die too soon.
This has to stop. They can't be doing this to other people. You're dealing with people's lives and families.